Hi, this is Kim McAllister, and we're going to move forward to Chapter 25 and talk about the legal issues, the regulations, and accreditation as it applies and revolves around IT health. You may not think that information technology, the electronic health record, and so forth have a lot to do with legal issues or that there's a lot of legality involved behind it, but this is healthcare and we have a lot of regulation. And the Joint Commission actually has some specific criteria for the electronic health record and for other aspects of healthcare IT. And so we're going to take a look at that. First of all, we're going to do a very brief review of civics, of your federal laws and the Constitution. And if you feel really well versed in this, then you may just want to slide right through this. I promise I will not be long. Understand that we have a Constitution. Yay! And the Constitution spells out the fact that we have federal powers and we have state powers, and we have to make sure all of these laws don't conflict. So basically the long and short of it is that the Constitution gives express powers to the federal government. There are express powers and implied powers. And the express powers are the powers that are specifically granted to Congress. Just like one of those is the ability to regulate interstate commerce. And they also can create regulations for those receiving federal funding. Does that send off any ding, 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 ding in your head? Because what about Medicaid, Medicare, TRICARE, the VA, and all of that? All of those medical systems operate on federal funds. And so if you're going to accept patients or take care of patients who are on these federal insurance programs, then you better believe the federal government has something to say about how that care is given. There's also such thing as implied power, and this is power that it's not specifically defined in scope, but it's sort of implied. And one of those is the necessary and proper laws. Congress can enact necessary and proper laws in order to carry out all the expressly written ones. Some of those implied laws would include HIPAA. Everyone knows what HIPAA is, and also the meaningful use for electronic health record. That falls under the implied powers. Any powers that are not expressly given to the federal government can be given to the state. However, if a state makes a law that encroaches on federal power, then that state law becomes invalid. There are concurrent powers, powers that are given both to the federal government and to the state government, such as both the federal and the state government can regulate privacy of personal health information on your electronic health record. Now, the federal government and the state government are actually working together on the whole issue with electronic health record and privacy and safety and so forth. And they're working together to keep from each issuing laws that conflict or cause problems with other laws. So they do talk to each other, which is kind of reassuring to know. And this just is a depiction of the federal healthcare regulatory framework, and that you have laws and then regulations and then advisory opinions. And you can see at the big picture there is greater weight and less specificity. And as it goes up to the top, you have lesser weight but more specificity. So I hope that's kind of a good illustration there. Enforcement of law. There are administrative mechanisms to enforce some laws, and also the ability to investigate and enact a wide range of penalties. We're going to talk about those a little more specifically when we talk about the specific laws. So we'll talk about the penalties that are involved. And some of these penalties are pretty huge and can pretty effectively put you out of business. So we have to pay attention to that because, believe it or not, your day-to-day documentation for your patient can ultimately either be okay or end up causing the hospital tens of thousands of dollars and other types of penalties. So we need to be really, really careful about what we're putting in there. Understand there's also, besides administrative, you have the court system, and the court and administration together. And so all of that gets to be very time consuming and costly when you have to stop and go to court and you have to answer complaints and fraud claims and so on and so forth. So it's really important to be very straightforward with what you're doing. And if you're responsible for designing and maintaining the health information system for your hospital, or if you're the informaticist and you're sort of the person who's in charge of making sure all of this is working correctly, then you want to be very sure that you're aware of these legal guidelines in detail and that you're following them all, which is not easy. Okay, first of all, let's look at the Stark Law. This was enacted in 1992, and this says that physicians can't refer patients to places that would end up giving them profit. So that means a physician cannot send you to a facility or a place that they own or that they have ownership interest in, or that will benefit their immediate family. They also can't send you somewhere that has a compensation agreement with them. And that leads into the federal anti-kickback statute. And this says that you can't exchange or offer to exchange anything of value in an effort to induce referral of federal health program beneficiary. So what this says is a physician who owns an office can't lease office space to a physician if that physician is expected to turn around and refer patients back to him. So let's say you are a physician who is a cardiologist, and you lease an office space to a general practitioner physician or a family practice doctor. And then you're expecting this family practice doctor to turn around and refer patients back to you for their cardiology needs. Can't do that. That's against the law. The other thing this also addressed was drug companies. Pharmaceutical companies used to give fabulous vacations and all kinds of incentives to doctors who would, based on like the numbers of patients that they would prescribe their medications to. And this got to be a big issue, and that's one of the big things that this law looked at. Safe harbors. This is where the federal government provides a way to be protected from the two aforesaid laws. Now you may ask yourself, why would the government want to prevent this? Well, it turns out that this had some pretty significant impact on practitioners and what they could do. And so they've decided that they needed to look at ways to allow people who were not doing these things in order to profit financially from it to be able to continue to function. And so people that want to do these things under, that are not trying to do this to steal money or whatever, they have to apply. There's a process for them to apply to be exempt from it. And there's a set of kind of rigid guidelines, and those are in your book and you can look at them. But the main thing is that the payments that are made to the physician have to be fair market value. So they can't be inflated, and it cannot involve counseling or illegal behavior. There is a specific safe harbor for information technology. This came about in 2006. And this was done so that small offices and individual practitioners, physicians' offices, and other providers would be able to afford an electronic healthcare system, electronic healthcare record system, because these systems that we use are incredibly expensive. They're overwhelmingly expensive. So the donor can donate the EHR, but they can only donate up to 85% of the cost to both purchase and to implement it. So the business has to come up with the other 15%. So this lets hospitals and large companies donate these to physicians and practitioners who otherwise could not afford to have an electronic health record or full informatics system. And it allows them to do this and not violate the Stark or the antitrust laws, which is good. False Claims Act is pretty much what it says. It's civil liability for submitting a claim for something that you didn't do or a false claim, and it imposes a significant penalty. It's 3 times whatever the claim was, plus an additional $11,000 per claim. This can be a problem because the electronic health record is going to produce a claim for every time someone comes in for services. If this claim is inaccurate or has some kind of problem and it goes to a federal insurance like Medicaid, Medicare, TRICARE, and so on, then it can be considered a false claim, and this can be bad. And the provider does not have to demonstrate any intention to commit fraud, so it can be a mistake. Also, if the provider gets overpaid, if they file the claim wrong and they end up getting more money than what they were supposed to get, they have 60 days to return the overpayment. Otherwise, they get charged for a false claim. Wire and mail fraud. If you put a false claim in an envelope and mail it, then you have committed mail fraud. And mail fraud brings charges of $1,000 in cash and 5 years in jail for every single claim. So if you sent out 50 claims and they were all false, you are in trouble. Now that we have the internet, if you do a wire claim, through the computer system, then that's considered wire fraud. So you're still on the hook for this. So you can see that it's really important for your electronic health record system to be very, very accurate. You don't want to be charged for things you didn't do. Fraud and abuse and the electronic health record. Each entry that's placed in that electronic health record determines what the bill is going to be to the insurance company. And as nurses, we've been told for years and years and years, be sure that you document every single thing that you use for the patient. Because if you don't, then it doesn't get paid for. So if you go and do just a simple dressing change, you want to document that you cleaned the wound and what you cleaned it with, and what you put on the wound, what you covered the wound with, what you wrapped the wound with, what you taped and secured the wound with, or if you're using a tegaderm or whatever you're using, you want to make sure and enumerate it all so you get paid for it. The problem is that sometimes some places are encouraging people to over-document and say that I did this and I did this and I did this. Understand that if you do that, then you are participating in fraud and abuse, and you can get in a whole lot of trouble. So the other issue is billing for services that were not needed or were not provided. There are also services that are considered bundled. In other words, if you're having a particular procedure done or you're going in for a particular type of visit, certain parts of that visit may all be considered bundled, and it's all in one CPT code. And so you can't turn around and then charge for part of that procedure again separately. Another thing that can happen is upcoding, and that's where the patient is coded at a different level than they are. Like they went in and had an uncomplicated appendectomy, but it gets coded out as a complicated appendectomy. And so the pay can be, $5,000, $10,000, who knows what, more than what it should be. Always take time to flip through your chart and see what the coding is. Not because you're looking to nail anybody for abuse, but because you want to be sure that your patients are being coded correctly. Sometimes a patient comes in for something that's routine and their condition gets worse and they end up having a complicated condition. And you want to make sure that that gets uploaded also, because just like we don't want to get charged for committing fraud, we also don't want to miss the opportunity for getting paid for what we actually did. So understand that your patient record, the things that you document every day about your patient, are part of a much bigger system, part of the financial, the billing, and personnel and so forth framework. I think we discussed this in chapter 6 or 7. But all of this ties together. And so if we get in a rush and don't get everything documented, then we may not get billed for everything that we do. And then the other thing to understand is state law. State law are also, besides these laws that we just talked about, there are state laws and regulations about billing and fraud and so forth. So not only can hospitals or agencies be subjected to federal law, there can also be state penalties on top of all of this. It's a dangerous world out there. Oh, and these are all the things about all the laws that I just went through, so you'll see these in your notes. Accreditation. CMS, that's the Center for Medicare and Medicaid Services, has designated the Joint Commission and the DNV, Det Norske Veritas, as third-party agencies that can accredit hospitals. And they each have their own accreditation program. But only the Joint Commission provides a program of health information management chapter, which is kind of nice. They issue all sorts of information and education, as well as come and observe and audit your hospital and send everyone into terror. So they both follow the Medicare guidelines for participation. And the Joint Commission, they both have survey and audit programs. The Joint Commission has survey and audit programs that are specific to the healthcare industry. These are detailed care-based standards. They provide guidance documents, and they also publish alerts and recommendations for issues. So some new issue comes up, they provide some type of documentation and assistance to help you in dealing with it. The DNV uses the National Integrated Accreditation for Healthcare Association Organization program. And this also evaluates hospitals based on the Medicare participation, but they use the International Organizations of Standards of Quality Management. So they're more focused on quality management, but they don't really provide any additional guidance. And maybe they will as they grow and develop and become a bigger organization. They may start doing more of what the Joint Commission does, but they don't right now. The Joint Commission has 4 main standards that relate to information management. Those are planning for management of information, using health information, using knowledge-based information, and monitoring the data and health information process. Each one of those further standards are divided into separate performance standards. So there's specific performance criteria for each one of these standards. An example would be you have to identify elements for planning in the information category. So in planning for management information, you've got to show how you're going to do that. You've also got to show how you're going to provide safe and quality care, how data is going to flow through the organization. Where does it go? You put in all this information. Where does it go? Who can see it? Who can't see it? What are you going to use it for? How long are you going to store it? Where is it going to be stored? How is it going to be secured? How are you going to prevent people from hacking into your system and so on? Also, how is your staff going to use this information in the provision of care? You've got to be able to enumerate all of that for the Joint Commission. So just some things to think about. There's also some Sentinel event alerts that have been released based on potential hazards. There's actually been hazards to patients, Sentinel events that have happened because of malfunctioning of information technology. In 2008, there were 2 preventable events, and one was related to the human and machine interface. The other was related to the overall design and organization of the healthcare system. So the Joint Commission's response is that healthcare organizations have got to take more time in designing the information system, and they also have to implement better training. So it's not enough just to create this system. You've got to be able to train people and make sure they understand how to use it. And they have to be able to sit down at the computer and interact with it correctly. There was another episode in 2015, and they identified 8 areas of weakness. And we're going to talk about the top 3. First, 1/3 of the events were due to the human-computer interface. Gotta have good computers. The next was the workflow and the communication issues related to IT support. You need to know your IT people. Your IT people need to know the user people. And all of you have to communicate together. You've got to be able to talk to them and explain why things aren't working and understand that they don't necessarily understand why this is a bad thing when something is going wrong. It's very important to remember not to make assumptions and to sit down and talk with them and explain what the issues are so that they can understand. If something is super critical, don't expect the fact that they immediately know this is something that's got to be fixed now. That people will die, people will be hurt if this is not fixed now. You've got to underline that because they may not have any health experience and may not be able to relate what's going on to what's happening to patients. That's our job. Also design, the third thing was design issues related to critical content and decision support. So the recommendations for dealing with all of that were 3 main recommendations. We need to increase the culture of safety. That's where when something goes wrong, we don't turn around and point fingers and figure out who to blame and then hold somebody up as an example and destroy them. What we need to do is be able to talk within and without the organization about the things that have happened. In other words, we, the hospital, have to be able to talk to them, the IT vendor, and say, this is why this is not working, and we need to fix it. The next is process improvement. We need to make programs free from malfunction, free of errors, and we also need to make them safer, and we need to make them monitor patient safety. So we've got to develop our IT systems that are more focused on preventing problems with patients. The next is hospital and facility leadership. Leaderships need to encourage the culture of safety. They need to encourage reporting, and they need to decrease blame. They need to be proactive in asking IT users for feedback. How is this working? What's not working? And how can we make it better? So this, in short, talks about how regulations and laws and accreditation is all heavily impacted by IT and vice versa. So if you're going to set up a system and run it, or if you're going to be involved in working in it, and all of you are if you're taking care of patients, because they're here now, these systems are here now and they're not going away. We've got to know what our rules are, what our regulations are. We need to know how to avoid causing unintended problems and how to keep everybody safe and keep information safe. Next, we want to think about our medical devices. Medical devices are regulated by the FDA, and they can include anything as simple as dental floss and be as complex as heart valves. And there's a table on page 431 in your book that you can take a look at, and it talks about how they're low, medium, and high risk devices, and you can see what they do. mHealth, those are things like your Fitbit or your watch or whatever that are monitoring your health status. Some of them will monitor all different types of vital signs and so forth, and you can track how much you walk or what you eat and so on and so forth with them. Regulators aren't really involved with them, and there's no real clear delineation about who gets the information from it and what they do with it. Sometimes health insurance companies will offer you a discounted insurance rate if you agree to wear their devices. What they're doing with the information they're collecting from that, who knows? They may look at that and say, hey, they're at risk for this or that, and so we're going to up the rate. I'm not saying that they will. I'm just saying that's something that could happen. social media and informatics. When smartphones first came about and phones with cameras in them, we had problems with people oversharing on social media, taking pictures of patients. There was a case, I think it was in another country, where a medical student filmed someone having a chest tube inserted, and you could clearly see the patient's face, and then they put that up on YouTube. There's been, pictures of patients have been shared. People have made remarks about patients or their hospital or so forth when they're at work. And so most organizations now have employees sign a statement saying, I understand I'm not supposed to upload anything on social media about patients or vital information that could be construed as medical information and so forth. And the National Labor Board is trying to fight that and come out with a law against that. And there's a big concern in the healthcare industry that that's going to cause more problems with patients' information being released. So a lot of things to think about here. I hope you enjoyed this chapter and are enjoying learning more about informatics.